qualified.
David Seltzer, Cheney Mason told me in the immediate aftermath of the trial when I was talking to him and Jose Baez that they initially rejected going for the death penalty and then reinstated it to get a death qualified and presumably more conservative prosecution-oriented jury. Do you agree with that?
I don't agree with that, and I think they definitely overcharged this case. And had they focused their attention on lower charges, they probably would have gotten the jury on something else. But they set the bar so high that they made it impossible for the jury to come back with anything because the jury was so far out there. There was no evidence from the beginning, and I know Stacey's convinced that it's murder all the way and that she did it, but the jury just said, not guilty, there's insufficient evidence. If they would have charged a third-degree felony, I think the jury would have come back with the lesser third-degree felony because they would have been focused on it. But there were no aggravating factors here to charge aggravated child abuse. There was no nothing for murder. There was no nothing for manslaughter because they didn't focus on it. They were so focused on the death penalty, as you said, eye for an eye, they didn't get it. I agree 100% this was politically motivated and driven.
I don't know where everybody gets that idea from. I don't know where everybody gets that idea from. The bottom line is when they went in that jury room, they rejected all of the arguments of the prosecution. They went in that jury room, they saw a picture of a kid standing in front of a sliding glass door and a picture of a child at a pool. And they went back and said, well, it's reasonable to think, based upon no evidence presented, that this child drowned. They
Stacey,
believed
it's 100%.
all of the prosecution's argument.
Okay, everybody
it's 100%.
Take a time out. Everyone will have a chance to respond. Also on this provocative question.
They're not going to charge her.
Why not?
I don't know.
Because there's too many lies back and forth.
They can't
it's a
charge
waste
her.
of taxpayers'
What's the point?
money. Yeah, it's
What's the
ridiculous.
point, says David Seltzer. More from you, David, coming up. What about junk science?
First, doesn't that make so much more sense than duct tape and chloroform?
But David Seltzer, let me go back on the other point. Good report. On the point of the smell evidence. As a defense counsel, do you fear the rush to certain forensics, or isn't it inevitable that as technology evolves, this is what defense attorneys will be confronting, and this is what prosecutors will be required almost by their juries to present?
Look, DNA has a match, and everybody has a DNA match to almost a certain probability that it's you. The fact that there's a smell in the car and it's completely subjective and you can't tell me whether it's the smell of a dead cat, garbage, or a human, there's no way you can do that. The jury wants to see something. They want to feel it. They want to understand that they can hold the DNA results and compare them. You're asking the jury to find on a subjective smell. I don't think this science, as Jose called it, junk science, will ever be widely accepted. I understand DNA started off like this, but this is something purely subjective that nothing can ever be confirmed. So unless you're going to figure out a way to bottle the smell, you're not going to be able to get a jury to buy it, in my opinion.
I think that it will be difficult, but I mean, obviously, as peer review and things like that happen, that did not happen with the smell evidence. I think that it will be a time where if it can be objectively quantified, it will be widely or much more widely accepted than it is now. But it was way too early. But I understand that desperation. What, David, you want to say?
There's no way to make it objective. It's purely subjective because you're asking someone to use their nose and smell an odor.
Maybe the guy's sniffleizer or whatever the hell it was. But anyway, let me put that aside. The fact that anyway, so.
Who cares about that? I don't know why you guys are getting caught. I'll tell you why. Because they didn't even need to specify a cause of death.
But
you don't
the
have
smell
to
of
have
death,
that
they spent how many? What, a week?
I get what you're saying. I wouldn't have done that. You don't need to get hung up on it. Negligence
how do you make something positive? David Seltzer, any objection that you have? Here's just my very brief caveat about this. You know, you have a 17-year-old. At what point does your tardy teenager become a missing person as opposed to someone who's just telling mom and dad, screw you? It's one thing if the child is dead, obviously, the 1 hour. But is 20, well, tell me from a criminal defense attorney, and then I'm going to get Kimberly on the prosecution side, about Kaylee's law, which are clearly going to be passed and passed in a hurry in many states across this land. Go ahead, David.
Yes, it's going to be passed. There's nothing that we can do to stop it. But you're creating such a slippery slope argument, like you said, that we're going to have too many exceptions built into this rule right off the bat. We have a statute on the books here in Florida. It's called child neglect. Not aggravated child abuse, but child neglect or simple child abuse. If the state would have had that as a lesser included charge, you probably would have had her guilty of that, and the judge would have given her 9 years instead of 4 years.
You know, David,
so
let me tell you,
let
me just add, I think I've read the obstruction of justice statute, and it doesn't apply in this case the way I read it. It's you know, paying off a cop. There are a lot of different clauses, but I didn't find any that matched Casey Anthony's clear lies to the cop. I think you need an enhanced obstruction of justice rather than the Cayley's Law. I mean, I'll take the Cayley's Law, but it's so specific, and it's got so many problems with it. Anyway, go ahead.
If you put in you know, what's the exception for the obstruction? If a child's involved and then you don't report it, then your obstruction becomes more serious. I think what they're trying to do with Cayley's Law encompasses all that. But again, we already have it on the books, and this is just a basis of overcharging and not putting that lesser included in the jury verdict form.
Okay, reckless homicide could get up to 25 years. Should have charged it. Anyway, as sincere as the outrage of the verdict over the verdict is, what?
Homeowners.
An adoring mother to someone that doesn't report their kid is dead.
She's been proven to be a good mother.
Be as sarcastic as you want. There's no evidence, not one witness, as Kimberly admitted reluctantly yesterday.
Wait a second. Wait a second.
May I give Mark Furman, the retired,
you have a dead child.
Formidable detective,
she's a bad mother. The child's dead. Even through negligence, she's a bad mother. You
she's a good mother because she rolled on the floor with her kid a couple of times.
I can't do this anymore.
Well, I got another hour to devote to you.
Detective Mark Furman, I resent people